I'm Drew Stevenson, and this is a lecture for my administrative law class about the case, the Board of Regents of State Colleges v. Roth. This is a 1972 Supreme Court case about due process for government employees. Now, for my students, keep in mind that this is a companion case to Perry v. Sindermann. The Supreme Court released them on the same day, finds different reaches different conclusions in the two cases, and they're both about state college professors being fired without a hearing. And what the Supreme Court did is they used these cases to set the bookends, so to speak, for the doctrine of due process for government employees. So let's go back to our slides and see what happens to Mr. Roth. The Supreme Court had decided this, as I said, with Perry v. Sindermann, but they reached opposite results in the two cases about the professors who were fired without hearings. Now, from the standpoint of administrative law, these cases are about whether a government employee, being a government employee, entitles someone to some due process when the person is fired. And remember from Goldberg v. Kelly, which was a couple years before this, that the Supreme Court had said there's a first step or an antecedent question in these cases where you have to decide if due process concerns are implicated at all. Not just did we give enough due process or procedural protection, but is this one of the situations where the government is supposed to provide procedural protections? And that antecedent step is to ask if there's a liberty interest or a property interest at stake. And when it comes to government employment, they say no, in this case, for liberty interest and maybe for property interest, but not for Mr. Roth. Now, don't get confused for my students. They're not saying that everybody in America has a right to a job or a right to government employment. Instead, they're saying that once you have a government job, you might be entitled to some procedural protections or given an opportunity to be heard before we take it away from you. So it's a very different situation if you haven't even attained the government position yet than if you already have it and we're firing you without giving you a reason. Okay, let's go back to our slides. In Roth, the court said that no hearing was necessary because Roth was on a year-to-year contract. In fact, he was in his first year of teaching and he was not tenured, and therefore the court says he had no reasonable expectation of continued government employment. This was very contingent, and he knew that at the end of every year his contract would have to come up for renewal. And what the university did is they just decided not to renew his contract. So they didn't technically, their position is we didn't technically fire him. We just announced that we weren't renewing the contract for the next year. So the Supreme Court says if there was no expectation of ongoing government employment that was reasonable, then there's no property interest. And if there's no property interest, then there's no due process implications. And if due process or procedural protections are not required, then the college did not have to give him a hearing. In contrast to Roth, the plaintiff in Perry v. Sindermann, the companion case that is also about firing a state college professor without a hearing, he won his case. The court said he should have received a hearing before termination. Why? Well, remember, Roth was on a year-to-year contract that wasn't renewed, while the professor in the other case had been teaching for many years at his school, and the court decides that he has something like quasi-tenure. So they construe his employment situation, even though he officially was untenured, they decided that he constructively did, and therefore he had a property interest, and therefore he deserved a hearing. That's the big takeaway from these cases, is this is about whether you get a hearing and whether you have a property interest when you're a government employee. So the bottom line for Roth and for Perry v. Sindermann is that government employment can create a property interest once you have it that could entitle you to some procedural protections. Please keep in mind, they can still fire you. They just have to give you a hearing. And that's part of what's puzzling about this case is all they had to do was call him in and set an appointment and have him come in for 15 minutes and explain why they were firing him and so forth, and we wouldn't have an issue here. Now, in terms of timing, this case and Perry v. Sindermann are decided in the period of time between Goldberg and Matthews v. Eldridge, which are two other cases that are in your administrative law casebook. Keep in mind that Roth and Perry v. Sindermann are about the question of whether due process even applies, specifically to government employment situations. So the opinions develop and clarify the notions of property interest and liberty interest from Goldberg. So Goldberg kind of rolled out this first step of asking, is there a liberty interest or property interest, to kind of introduce the terminology, so to speak. And then Roth and Perry v. Sindermann really discuss and clarify what these two concepts mean. Matthews v. Eldridge, in contrast, is about the timing of the hearings, and that was the other issue in Goldberg v. Kelly. So in Matthews v. Eldridge, there was never a question about whether Mr. Eldridge was going to get a hearing. It was a question of whether he gets it before or after his benefits are terminated. Now, there's a backstory here I want you to know about. Roth, even though he was in his first year of teaching, it was 1968 in Wisconsin in their university system, and he was an outspoken critic of the administration, even in class. And I know that there's students who would object to that even today. You shouldn't speak against the administration in your class, but he was upset over its handling of a Black student protest that had occurred on the campus that semester. And what happened is 94 Black students at the Wisconsin State College Oshkosh were arrested and expelled following a November 1968 protest. And this came to be known as Black Thursday. What had the students done? Well, they had gone together as a group to the president's office one day, the president of the college, and demanded that he address some racial inequalities on campus. And they had a list of suggestions and things like having a few courses. Maybe the college could offer some courses in African-American literature and history, or they could hire some Black instructors, which they weren't doing at the time, or at least not enough. And so instead of even agreeing to any of their demands, the university had them arrested and jailed and then expelled all of them. And Roth was upset. He wasn't the only one. So this happened in November at the end of a semester in 1968, right before finals. And the next spring, early in the spring, there were massive student protests and strikes, peaceful marches in Madison, at University of Wisconsin-Madison, the other campus, which kind of triggered a bit of a violent overreaction from the Madison police, and eventually the National Guard is sent in to stop it. And one of the protesters' demands was that the University of Wisconsin at Madison would admit the students who had been expelled the previous semester at Oshkosh. They had other demands too, but there was clearly a connection between what happened that was the backstory for Roth and what came to be known was actually kind of a historic protest in Wisconsin. And here we have the National Guard dominating the streets, to quote a government official from 2020. The court in Roth, though, didn't really consider his First Amendment claims. He said that he had been fired basically as a retaliation for speaking up about this injustice. And the court said that basically his First Amendment grievances were not properly before the court. Justice Douglas wrote a dissent and actually gives us the backstory in his dissent briefly, and he wanted to address the free speech issues in this case. What's a little bit frustrating is that the court was willing to address some of the free speech issues in the companion case, Perry v. Sindermann, and they don't seem all that different, except Perry v. Sindermann was about what types of degrees the college would offer instead of racial injustice. So that concludes our little lecture about the Board of Regents v. Roth case, and we will have a companion video about Perry v. Sindermann.